Chapter 7. The conceptual argument for the judicial obligation to develop the law. In the previous two chapters, I discussed the legal sources that ground a legal obligation for common law judges to develop the law by refusing to enforce unjust laws. In addition to the source-based argument, a conceptual argument based on the nature of the common law judicial function supports judges developing the law in this manner. I call this argument conceptual because it is based on the concept of the common law judicial function. The term common law judicial function refers to a quadripartite concept, with each of the four words in the term designating a particular concept. For this chapter, each part of the concept is important. It is important to my argument that we are discussing judges, the people who are in the business of making judgments. It is important that we are discussing those judges who make judgments about or according to law, as opposed to those who reach ecclesiastic or aesthetic judgments. The particular judicial function that is important here is the deciding of cases through the articulation of published, justificatory written opinions. It is important to my argument that we are discussing judges whose decisions are understood as being justified according to law and legal reasoning. And it is important that we are discussing this judicial function in the context of the common law tradition. Of the components of this compound concept, the last is the most important. The common law tradition places particular importance on judicial decisions and decision-making. And according to this tradition, common law judges are central to the development of the law. To sum up the conceptual argument in one sentence, the common law is designed to develop over time in the direction of justice. Judges are the primary institutional actors designated by the common law system to guarantee that this development takes place. And when they fail to meet that obligation, serious negative consequences ensue. In this chapter, I divide the argument into four sections, broken down in accordance with its progression. First, I offer an argument to explain how the common law's developmental design can be seen. Second, I explore the relationship between common law judges and justice. Third, I examine some conflicting understandings of the judicial function and defend the one that best incorporates the full measure of common law judicial authority and responsibility in ensuring the common law's doctrinal development. Finally, I examine some of the damage done when common law judges fail to ensure the common law's development. In an effort to reduce the abstraction of the argument, I will refer to a famous improvement in American law regarding racial segregation as a leitmotif of the issues I discuss. Before turning to the four prongs of the conceptual argument, though, I begin, in the next section, with a short explanation of the complexion of the obligation, for which I will argue. A. Role obligations. When one agrees to assume the role of a judge, one assumes certain responsibilities attendant to that role. Since no one has to be a judge, writes Kent Greenewalt, those who assume official positions implicitly agree to perform the duties of those positions. The question is, what duties has a judge implicitly agreed to perform when she assumes her role as a judge? I have already explained that one responsibility of the judicial role is the faithful application of the law. I have also already mentioned that this is not the only responsibility engendered by the judicial role. The responsibilities that attach to one's role are sometimes referred to as role duties or role obligations. To avoid repetitiousness, I will use both terms, but I will omit the word role, with the qualification that when I use the terms duty and obligation in this chapter, I always only refer to duties that are inherent in or derivative of the common law judicial role and function. Whichever term is used, my argument adapts the idea as it is described by Greenewalt. A duty attaches to a particular position or to one's status as a human being. One speaks of the duties of judges and parents and of people generally. In this usage, one can speak of moral obligations and duties, but one can also speak of obligations and duties that are other than moral. These non-moral duties or obligations may carry moral weight. It is morally right that judges perform their legal duties, but moral argument is needed to link the non-moral duty to what one morally ought to do. In my conceptual argument for a judicial duty to develop the law by refusing to enforce an unjust law, I invert the progression suggested by Greenewalt. I do not assume the non-moral legal duty of judges, and propose a moral argument to link the non-moral judicial duty to what one morally ought to do. Instead, I assume, as most people do, that a judge morally ought to refuse to enforce an unjust law, and I propose an argument to link the moral duty to what a judge legally ought to do. This is because I am interested in challenging the prevailing assumption, which underlies the moral formal dilemma, that a judge's moral and legal duties conflict in cases involving unjust laws. As I will argue in this chapter, and in the 2 chapters that follow it, the link between a judge's moral duty not to enforce unjust laws and her legal duty not to enforce unjust laws is found in certain fundamental common law principles, which are relied on by English and American judges when evaluating the legality of government action in both systems. B. Disagreements about the law, dissenting opinions, and the design of the common law. In discussing Lord Mansfield's statement in Omachund that the common law works itself pure, I mentioned the methodological and doctrinal components of this concept. In Chapter 5, I discussed the doctrinal aspects of Omachund. But Mansfield was not, it seems to me, just advancing a legal argument based on the facts and issues of that case. He was identifying an intrinsic feature of common law legal systems. Fundamentally, the idea and the image of the common law working itself pure are attempts to depict the common law's nature. The common law is designed to develop over time. We should not, however, allow Mansfield's evocative phrase to overshadow the fact of the matter. The common law does not work itself pure. It is worked pure by judges. In this aspect of the common law judicial function, we find the central place of the judicial process in the common law system and the central place of the common law judge in the judicial process. The common law is designed to develop over time and develops through judicial effort and experience. This development is usually incremental and gradual, but occasionally dramatic. However it happens, the point remains the same. The common law system assigns the role of developing the common law to its judges. The common law method requires judges to state the reasons for their decisions, so that the decisions can be justified to the litigants involved and used as authority in later cases. The paramount importance that this method gives to judicial opinions as records of judicial reasoning and justifications for judicial rulings can hardly be overstated. Simply put, the way judges write their opinions matters, for the litigants and for the law. The opinion thus engages in the central conversation, that is, for us the law, a conversation that the opinion itself makes possible. In doing these things it makes 2 claims of authority: for the text and judgments to which it appeals, and for the methods by which it works. These things can be done well or badly in virtually every dimension. It is important that they be done well, not only because it is important that the parties be shown that their case has been treated with intelligence and respect, but because the way the opinion is written has large consequences for the future. It deeply affects and shapes the way we think and argue, and in so doing constitute ourselves through the law. If an opinion is narrow-minded or unperceptive or dishonest or authoritarian, it will trivialize the experience of those it talks about, and it will trivialize the law too. If it is open and generous, full of excitement at the importance it gives to the events and people it speaks of, and to its own treatment of them as well, it will dignify the experience of those it talks of, and in so doing it will dignify the law itself. It may even be touched with nobility. The way opinions are written is important even, or especially, when judges disagree about the law. When judges agree about the proper result in a case, but disagree somewhat about the proper rationale for reaching that result, concurring opinions permit judges the opportunity to provide their best understandings of the legal justification for the result reached. Dissenting opinions provide judges who disagree about the proper result in a case the opportunity to explain the legal justification for the divergent results they reach. As a common law innovation and a heuristic device, dissenting opinions serve as symbolic and tangible evidence that the common law is designed to develop over time. In some notable instances, we can actually observe this development through the law's adaptation of what began as a dissenting opinion into a majority opinion and eventually into settled legal doctrine. Perhaps the most famous example of this at least in the United States, is the progression of American law from Justice Harlan's dissenting opinion in Plessy to the unanimous decision in Brown, with Harlan's prescient prediction in his Plessy dissent of the ignominy, into which the majority decision in that case would finally descend. Someone might object that Plessy and Brown are poorly chosen as illustrations of the influence of dissenting opinions on legal development. After all, Chief Justice Earl Warren went out of his way not to cite Harlan's Plessy dissent in Brown. In addition, the point is sometimes made that in Brown, the Supreme Court never expressly overruled Plessy. Far from rendering these cases inapt as an example of dissenting opinions influencing the development of the law, however, these aspects of Brown highlight the common law's developmental design and the relevance of dissenting opinions to it, because Brown reveals judges working the law pure, while either failing to give a candid account of their reasons for doing so or failing to rely on the right sorts of reason. First, let me address the claim that Brown did not overrule Plessy. While this claim is accurate so far as it goes, it seems a bit hyper-technical. As a result of Brown, racial segregation in the sphere of public education is prohibited beyond cavil in the United States. Furthermore, Brown effectively eradicated Plessy's separate but equal doctrine from American law, despite arguments that Brown was limited solely to education by its facts, and by its failure to overrule Plessy frankly in its entirety. Even more important, though, are the reasons given in the Brown opinion as the ostensive justification for the court's decision. For reasons related to the politics of the time, and to Chief Justice Warren's desire to maintain unanimity among the justices, the Brown decision was written in tempered tones. These social and political pressures may have led the court to mischaracterize the genuine foundations of its decision. Warren founded the Brown decision on social science data demonstrating the deleterious effects of racial segregation on black children. To a segregationist for whom Jim Crow laws were a welcome fact of life in the 1950s, it might have been more tolerable to hear that the Supreme Court concluded segregation was harmful to schoolchildren than to hear that the Supreme Court determined segregation was fundamentally unjust. The Supreme Court knew that its Brown decision might meet with strident, even violent reactions. The court may have done what it thought it should to minimize the extremity of these reactions. But even if one can understand the reasons why Warren wrote Brown as he did, it was a mistake to shrink from the principled legal decision that should have been written. The legal principle for which Brown stands is that separate, racially segregated facilities are inherently unequal, and therefore violate the 14th Amendment to the U.S. Constitution. Lawyers might disagree about whether Brown stands for the narrow legal principle that racially segregated educational facilities are unconstitutional, or for a broader legal principle prohibiting any state-sanctioned disparate treatment of American citizens based on race. Whichever understanding of Brown one favors, however, the court should have decided that segregation was illegal in the United States, simply because it violates the Constitution, not because of possible psychic harm to schoolchildren. The court's attempts to avoid overruling Plessy's permission for racial discrimination on the ground that Plessy did not involve education undermined the relatively simple, clear, and defensible justification for the decision with which the court started. The 14th Amendment should be interpreted as proscribing all state-imposed discrimination against the Negro race. To depart from this justification was unnecessarily to provide arguments for opponents of the decision and handicap its defenders. The justification for a decision is, like all explanations, a matter of adequacy rather than of absoluteness. No principle is more generally accepted, appealing on its face, or basic to American ideals than that a human being, or at least an American citizen in America, should not be disadvantaged by government because of his race or ancestry. It is no use to pretend that even this principle is an absolute, that it answers all racial questions and obviates the need for further thought, but it may be as close to a useful absolute as any we have. If one accepts this principle, as nearly all do, no more is required to justify the Brown decision than to show that the individuals involved were in fact disadvantaged by school segregation. No resort to psychology is necessary to show this. An individual is necessarily disadvantaged when he is confined to association with only a part of the society. Social science data are irrelevant to the legal conclusion that segregation or segregated educational facilities violates American legal principles. By basing its decision in Brown on social science studies, the court weakened the force of its legal contribution. The unavoidable problem with the court's reliance on these data is that the conclusions to be derived from the data are debatable. The fact that the scientific data may remain inconclusive, however, does not mean that the legal issue should as well. The court's reliance on scientific data will always leave open the specter of the converse question. What if it did not harm the self-image of black children to be educated in segregated schools? Should segregation suddenly be legalized? The problem with Plessy and the point of Brown is that, as a matter of legal principle, the U.S. Constitution does not permit the government to use race as a reason for treating individuals disparately. Why people react as they do to racial differences, and what harm is visited on individuals as a result of those reactions are fascinating psychological, sociological, and anthropological questions. But the debates surrounding those issues are not principally relevant to the legal question, and it was a mistake for the Brown court to enter into those debates. Whatever the court may have thought about the social science support for its conclusion, its ruling in Brown should rest squarely, unambiguously, and unmediatedly on legal reasoning drawn from legal sources and principles. That is what the common law obligation to justify legal decisions requires of judges. And this obligation exerts its force most acutely when a judge's legal decision is most likely to be controversial and even unpopular, as the Brown decision surely was. The obligation imposed on judges by the common law to explain the reasons for their decisions necessitates that the proffered explanations be complete and candid. The value of a judge's statement of reasons for a decision is lost if the judge does not state those reasons accurately. The danger is that this duty of exposition can be evaded. It requires candor from judges in addressing the strongest arguments against their views. The duty of exposition seeks to remind the judge that the power to do something is not the same as the right to do it, that right can be earned, if at all, through reason. Justly celebrated as the outcome is, the Brown court failed to do all it could in its decision to purge segregation from American society as a matter of legal principle. The point of Brown is, or should be, that American law prohibits racial segregation because segregation violates constitutional or other legal provisions and principles, not because segregation may or may not damage the self-image of the people subjected to it. Notwithstanding my misgivings about the court's reasoning in Brown, the outcome represents a paradigmatic example of judges working the law pure. The criticisms of the Brown opinion highlighted in the previous paragraphs demonstrate that outcomes alone are not enough, however. To meet fully their obligations in the common law tradition, judges must offer reasons that justify outcomes, no matter how justified the outcome may appear when standing alone. Nevertheless, Plessy and Brown are a fitting demonstration of the influence that reason and principle and a dissenting opinion can have on the law's later development. Brown and Plessy are, of course, just one famous yet flawed example of judges improving the law and of the influence of dissenting opinions on that process. The common law is replete with myriad examples of dissenting opinions, serving as the groundwork for what would later become the law. Dissenting opinions evince the common law's commitment to improvement over time. Dissenting opinions demonstrate that the common law is designed to improve, and that it does improve through the efforts of judges to articulate the reasons that they think best justify the result reached in a given case. The common law requires judges to justify their decisions as explanations to the individual litigants of the law's treatment of them, and to serve as precedential authority for later judges and lawyers to reason about the law. This common law practice depends on the candor and comprehensiveness of the judge's justificatory explanation. Anything less impairs the litigant's understanding of their own case, the public perception of the integrity of the judicial process, and later consideration of the rule and rationale announced in a particular precedent, whether by the majority or in dissent. Brown and Plessy represent an object lesson in all of these features of the common law. First and foremost, Brown is a source of pride for Americans as a judicial achievement in the cause of justice. Brown also built on, even if it did not explicitly cite, the courageous example of judicial integrity manifest in Harlan's dissenting opinion in Plessy. Harlan's dissent shows that when judges candidly state their reasons for refusing to enforce unjust laws, they meet their obligations as common law judges to assist the ongoing process of legal development, even if they are prevented from achieving their desired result in the case at hand. The dissenting judge contributes to the corpus of available precedent and helps as much as a judge can within the role assigned to her by the common law to develop the law. C. Judges and justice. When examining the connections in Coke's and Mansfield's thought, I noted the connections in the common law between reason and justice. The idea that the common law works itself pure expresses the common law's commitment to seek justice in the process of adjudication through the application of judicial reason to human experience and legal dispute. An essential part of the business of common law courts is, on this account, to strive toward justice. At times when judges find themselves faced with an unjust law, the obligations placed on them by their role within common law systems requires them to develop the law in the direction of justice. The connection of justice to law, on this view, turns out to be indirect and non-exclusive. It comes of the combination of two facts. First, that adjudicative institutions should be just above all. Secondly, that adjudicative institutions are, in a sense, the linchpin of all common law legal systems. If they are to be just, the courts should still not surrender to a rule that cannot be justly applied. In that case, justice would have the courts either change the rule or depart from the rule. The idea that adjudicative institutions should be just above all connects judges and the judicial process to justice. Where a legal rule cannot be applied justly, the judge's duty to seek justice requires the judge to change or depart from the unjust legal rule. This is what common law review requires of judges. This is a teleological view of the common law judicial process, with justice as its telos. Justice is what the judicial process is proceeding toward. This is, it seems to me, exactly what Mansfield had in mind when he spoke of the common law working itself pure. The design of the common law to develop over time dovetails with and depends on the common law judicial method of reasoning by referring to, relying on, and sometimes reevaluating established legal doctrine. This ongoing judicial reevaluation of existing law is the common law's assurance that the law will never stagnate or ossify. Judges will ordinarily find that the law is fine as it is. But when they find that it is not, the common law tradition intends for them to do something about it. The common law insists on the active application of judicial reasoning as a necessary part of the aspiration to justice. As Justice William Brennan has written, I am convinced that law can be a vital engine, not merely of change, but of other civilizing change. That is because law, when it merits the synonym justice, is based on reason and insight. Decisional law evolves as litigants and judges develop a better understanding of the world in which we live. Sometimes these insights appear pedestrian, such as when we recognize, for example, that a suitcase is more like a home than it is like a car. On occasion, these insights are momentous, such as when we finally understand that separate can never be equal. I believe that these steps, which are the building blocks of progress, are fashioned from a great deal more than the changing views of judges over time. I believe that problems are susceptible to rational solution if we work hard at making and understanding arguments that are based on reason and experience. In a system where justice is a public value, as it is in every existing common law system, judges must apply their reason and experience in the attempt to achieve justice, at times by rectifying or eliminating injustice. That is their role and their responsibility to the law, to the judicial institution, to the public, and to the litigants. The idea that the obligation to achieve justice is a fundamental element of the judicial role is hardly novel. Yet few people seem to appreciate that, in common law systems, this element of the judicial role is imposed or presupposed by the legal system itself. People resist the claim that common law judges may, by virtue of their role and responsibility as judges, refuse to enforce unjust laws. Such refusal will result So the argument goes, in unelected, unrepresentative, and unaccountable judges unreservedly imposing their subjective moral beliefs onto litigants and into the law by fiat. But this is what the common law has always expected. Moreover, as a practical matter, the law's relationship with politics might also help to explain why the common law has always expected its judges to engage in value judgments when rendering their legal judgments. In part, this is an unavoidable aspect of positioning an independent judicial system within a larger representative governmental structure. It is a means of restraining judicial action in relation to other branches of government. To argue that judges must evaluate the law without recourse to their personal values and convictions is not merely to suggest a cautious and prudent circumscription of otherwise dangerously elastic judicial discretion. It is, in fact, to argue against the common law as a legal system. Some have, from time to time, taken this position. This view is not incoherent, but it should be recognized for what it is. And those who adopt it should realize what their argument requires and suggest the type of legal system they would prefer as a replacement. We must understand that our epistemological conceptions and preconceptions concerning the judicial role relate directly to our ontological notions of a legal system. As a legal system, a legal tradition, a legal method, a mode of legal thought, and a body of legal principle, the common law functions at both structural and substantive levels. Structurally, if a legal system is a common law system, the common law in every sense of that term is relevant to the organization of government, the powers of government, the limitations of government, and the responsibilities of government. If a legal system is a common law system, the common law functions at a constitutional level, organizing and allocating power among the organs of government. This is an important part of the meaning of common law constitutionalism. In referring to common law constitutionalism, I mean that the common law serves as a principal source for determining what are considered constitutional rights and fundamental values, and that the common law method applies to the articulation, evaluation, and interpretation of the written or unwritten Constitution. According to common law constitutionalism, the common law must, at some level and in some fashion, constrain abuses of state power. Here structure meets substance. The common law system's form meets the common law judge's function. In any healthy common law system, the judiciary must exercise some meaningful measure of independence and interdependence. Common law judges must be independent, because many of the fundamental rights and principles maintained at the level of common law were first recognized or formulated by judges, and because the common law depends on its judges jealously to preserve and protect them. As Ruth Bader Ginsburg has observed, common law judges also play an interdependent part in our democracy, insofar as they do not alone shape legal doctrine, but they participate in a dialogue with other organs of government, and with the people as well. In their independence and their interdependence, judges bear institutional obligations to preserve the principles inherent in the common law. Common law judges cannot separate their role from their responsibilities. One of the fundamental principles of the common law is justice, and one of the fundamental values of a common law legal system is the pursuit of justice. Common law constitutionalism is, then, a version of justice-seeking constitutionalism. Even those who would restrict the common law judicial function concede justice's place as a fundamental common law principle. As I explained in Chapter 1, the fundamental principle of justice in the common law should not be understood, for purposes of my argument, as an abstract principle. The principle of legality, which I discuss in Chapter 9, and the principle of access to the courts, which I cite in Chapter 8, are two concrete contemporary expressions of fundamental common law principles of this type, operating to maintain legal constraints on public power in accordance with the rule of law. The common law serves as the structural basis of the judicial authority to review legislative and executive action, and provides a substantive standard against which this action is assessed. By requiring all common law judges, by virtue of their position and status as judges, to develop the law, sometimes by refusing to enforce unjust legislative or executive action, Common law review simply acknowledges a truth about the common law's systemic effort to attain justice and the judge's obligations in that process. The common law should be understood as a body of principle, which makes constant appeal to the requirements of justice. It must invite continuous debate and deliberation about questions of political morality. Properly understood, the common law serves the ideal of the rule of law by incorporating such deliberation within its ordinary process of evolutionary change and development. Without judges constantly and continuously appraising the law through the lights of their reason, the common law has no hope of achieving justice. The common law depends on the dynamic, recurrent exercise of judicial reasoning in the evaluation of the law, the resolution of disputes, and the issuance of decisions. It is not just irresponsible for a common law judge to suspend her reason and silence her voice when deciding a case. It is perfidious for the common law judge to deprive the common law of the benefit of her reason and her unique contribution to the cause of justice. For my own part, with all becoming deference to the great minds, whose province it is not only to enlighten by their wisdom and learning, but sometimes to enslave by their authority, my reason will not allow me to give my sanction, as a public officer, to doctrines so subversive, in my humble judgment, of the principles and theory of our republican, constitutional governments. It would be an abandonment of duty as well as reason, were I, under such circumstances, to resign my right and obligation of independent thought and opinion, which, I may add, it is not the least commendation of the noble profession of the law, that it inspires, encourages, demands. Reluctant as I am to offer any essentialist account of the common law or common law systems, there is one integral feature of all common law systems, and a legal system lacking this feature cannot accurately be designated a common law system. This feature is a judiciary whose obligation is to resolve legal disputes in an honest effort to achieve justice, through justificatory written opinions that serve as guidance to lawyers, judges, and citizens in subsequent reasoning and decision-making. It is not just a coincidence that we find this sort of judiciary in every common law legal system. It is what makes these legal systems common law systems. B. Disagreements about the judge's role. Interpreting the judicial function. Judges disagree about their role, and so judges disagree about their responsibilities. As I have already explained, some judges assume that their role is strictly limited to the enforcement of the law as it is. These judges believe that they exceed their authority if they refuse to enforce a law that is constitutional, no matter how unjust the law might be. Other judges see things differently. These judges consider their role and their responsibilities to be more capacious. Common law review requires judges to take the broader outlook. The common law has always required its judges to bring their moral faculties and convictions to bear on their legal decisions, as an essential contribution to the common law's ongoing development. This is true not only in the uncontroversial areas of common law adjudication. It is also appropriate, and most important, in what are now called constitutional cases. Of course, as I have already explained, the attempt to distinguish common law adjudication from constitutional adjudication is not well founded historically or doctrinally. But even those judges who seem to presuppose the distinction recognize the importance of the intersection between their moral evaluations and their legal determinations. These judges recognize the value of their values when deciding common law cases and constitutional cases. The disagreement about whether the role of judges limits them to the enforcement of a law irrespective of the law's injustice touches, inevitably, on judicial attitudes toward the part played by a judge's own values and sense of justice when deciding cases. Some judges deem their own moral faculties to be entirely irrelevant to their duties as judges to enforce the law. Other judges understand that their individual moral convictions and reactions are a necessary element of the legitimate judicial decision-making process. In his lecture in honor of Justice Benjamin Cardoso, Justice William Brennan declared his and Cardoso's membership in the latter camp. It is my thesis that this interplay of forces, this internal dialogue of reason and passion, does not taint the judicial process, but is in fact central to its vitality. This is particularly true, I think, in constitutional interpretation. Having admitted and demonstrated that judges inevitably confront value choices, Cardozo did not shrink from the implications of that admission. He rejected the prevailing myth that a judge's personal values were irrelevant to the decision process, because a judge's role was presumably limited to application of existing law, a process governed by external, objective norms. As Cardozo had before him, Brennan rejected the idea that the judicial role requires a judge to disengage his moral values when adjudicating legal disputes. On the contrary, Brennan decided that this moral engagement between the judge and the law was an unavoidable and beneficial part of the judicial process. In stark contrast with the view shared by Cardozo and Brennan, Judge Robert Bork sees his role very differently. Where the Constitution does not apply, the judge, while in his robes, must adopt a posture of moral abstention. Needless to say, common law review is predicated on the rejection and refutation of Bork's claim. But for now, I am interested in looking at the fact of this disagreement about the proper understanding of the judicial role, rather than discussing its resolution. Ronald Dworkin's theory of constructive interpretation provides an interesting analytic framework for considering this disagreement about the judicial function. Dworkin's two dimensions of interpretation, fit and justification, are frequently applied to determine what the law is at a given time in a given place. In fact, Dworkin himself applied his theory to explain the result in Brown. But we can step back from the immediacy of a particular legal question and apply Dworkin's interpretive theory to the practice of judging. In Dworkinian parlance, we may reasonably conclude that both Bork's and Brennan's competing views of the judicial role sufficiently fit the Anglo-American common law judicial tradition. The question then becomes, which interpretation best justifies the judicial function by portraying the judicial role in the best light? It seems to me that Brennan's view does. Unlike Bork's ideal of a moral abstentionist judge, Brennan's view of the judicial function permits judges to exercise their moral faculties while wearing their robes and when formulating and evaluating legal rules found in statutes and precedents. This vision better conveys the judiciary's role as an institutional counterweight against a majoritarian legislature, whose members must occasionally shield individuals and minority groups from legislative encroachments on their liberties. The Borkian quietist judge represents a portrait of a judiciary that reads its own responsibilities so narrowly as to vanish at the point when they are most needed, allows the law to remain static when change is urgently sought, and perpetuates injustice in the name of judicial restraint or deference. Most of the arguments for judicial restraint and originalism in their various forms boil down to arguments that the absence of explicit references to judicial review in the U.S. Constitution undermines theoretically and historically, if not practically, the exercise of that power by American courts. But the institutional functions of the common law judiciary call into question the significance of that omission for purposes of establishing autonomous judicial authority in reliance on legal tradition and legal sources. The scope and nature of judicial authority and institutional independence in the common law tradition were not initially, and should not now be conceived as created or completely circumscribed by a charter document. A common law foundation has long existed for the inherent judicial authority irrespective of a constitutional text to evaluate governmental action. In the United States, this means that resolution of the counter-majoritarian problem, if judicial review is truly counter-majoritarian, and if that is a problem, need not and ultimately cannot be resolved by reference to particular modes of constitutional interpretation, e.g. originalism, or by inveighing against the activism of the judiciary. In England and elsewhere in the common law world, as I explain in Chapter 9, this means that efforts to reconcile parliamentary sovereignty and the rule of law cannot be accomplished solely by resort to the ultra vires doctrine. The vision of judges whose moral values are necessary, worthwhile, and legitimate components of the judicial process is the vision embraced by common law review, because this is the vision intrinsic to the common law. This is the vision that best allows judges to prevent injustice by acting on their strongest and deepest convictions. The risk to the integrity of the judicial process and to the public esteem of the judicial institution is far greater when judges fail to bring their convictions to bear on their adjudication. That is what the common law has always expected of them. The danger is not that judges will bring the full measure of their experience, their moral core, their every human capacity to bear in the difficult process of resolving the cases before them. It seems to me that a far greater danger exists if they do not. The proper interpretation of the judicial function is not solely an academic exercise. Judges who disagree about the scope of their role and their duties will sometimes reach very different decisions in a given case. In considering different interpretations of the judicial function and the effect of these different interpretations on judicial reasoning and decision-making, there are four basic categories into which interpretations of the judicial function fit. The first category consists of judges whose functions and obligations are limited exclusively to applying the law as it is. On this account, the judicial role is minimally interpretive or evaluative. It is almost entirely instrumental. Of course, even judges in this first category must engage in some interpretation or evaluation when determining whether a statute or precedent should apply to a given set of facts. But this interpretation or evaluation is not supposed to be especially reflective or creative. I will call this interpretation of the judicial function instrumentalist. The second category adds something important, but limited, to the first conception. In addition to determining what the law is, these judges reckon that they must ensure that the law complies with the prescriptions of a constitution as understood by its framers. If and only if a particular law violates the original understandings of those who framed a constitution, then these judges determine they have the authority to refuse to enforce the offending legislation. If the law cannot reasonably be said to violate the provisions of the Constitution, as those provisions would have been understood by those who originally considered them, then the judge has no alternative but to enforce the law as it is. I will call this interpretation of the judicial function originalist. Originalist judges concede that they have some interpretive function when deciding what the Constitution's authors intended and whether a law contravenes those intentions. But this interpretive function is narrowly and somewhat rigidly confined. In the third category are judges who agree that they must ensure that particular laws comply with the Constitution. But these judges do not assume that the Constitution's meaning is fixed by the intentions or understandings of those who wrote it. These judges believe their function requires them to interpret the Constitution in accordance with contemporary legislators' or citizens' prevailing beliefs about social and political morality. I will call this interpretation of the judicial function interpretivist. The fourth category consists of those judges who agree with the interpretivists about the nature of the judicial function with one exception. When deciding whether to enforce a particular statute or precedent, they evaluate the law in the light of constitutional directives. But in cases of extreme injustice, these judges are willing to refuse to enforce certain laws, even where the law violates no particular constitutional provision. In extreme cases, these judges rely on their own individual moral convictions in preference to those of the community when evaluating and developing the law. I will call this interpretation of the judicial function individualist. Individualist judges would still view the Constitution as the first, and usually the last stop in the judicial evaluation of the enforceability of legislation or precedent. They also believe, however, that the Constitution is not the exclusive legal basis against which a judge might evaluate a particular law, and that in certain cases where the Constitution does not preclude some egregious injustice, there may be some other legal basis for judicial intervention. I argue that the common law provides this alternative basis for judicial invalidation of unjust government action. The first category represents the stereotypical civil law judicial function, as well as the position of some common lawyers and common law judges. The second and third categories encompass versions of constitutional review. And the fourth category is common law review as I envision it. Judges in each of these categories believe that they are deciding cases in accordance with their role and responsibilities as judges. I should say that most depends upon the judge's unspoken notion as to the function of his court. If he views the role of the courts as a passive one, he will be willing to delegate the responsibility for change, and he will not greatly care whether the delegated authority is exercised or not. If he views the court as an instrument of society designed to reflect in its decisions the morality of the community, he will be more likely to look precedent in the teeth and to measure it against the ideals and the aspirations of his time. To the litigants whose lives will be directly affected by the court's decision, and to the citizens who will live under the law established by the court's decision, the way a judge interprets his role and his responsibilities is a question of the gravest importance when it determines the outcome of a momentous case. Judges are responsible for their view of their role and its repercussions. The relationship among judicial role, judicial responsibility, and judicial ruling affects the way judges see one another, and the way we see the judiciary as an institution. This relationship can best be seen through the example of actual cases, such as Plessy and Brown. Let us assume that both Plessy and Brown fit American social and legal history and practice when they were decided. It is difficult to deny that Brown portrays American law in a better moral light, and is a better justification and interpretation of American law than Plessy. But now let us assume that originalist judges will view segregation only as it was viewed by the framers of the U.S. Constitution, while interpretivist judges will evaluate segregation in accordance with contemporary social morality. If we can accept that these two interpretations of the judicial function might lead to different judicial decisions, and that the latter interpretation of the judicial function will permit a better judicial decision, then this reveals the connection between the interpretation of the judicial role and the formulation of judicial rulings. The interpretation of the judicial function that permits the better interpretation of a society's law is the better interpretation of the judicial function. Common law review simply takes this argument one step further. Common law review fits Anglo-American common law traditions, methods, and sources, and affords the greatest operative latitude for the judge's personal values when faced with unjust laws. Individualist judges, with their proposed interpretation of the judicial function, come to better decisions in certain cases when engaging in common law review than judges who adopt other interpretations of the judicial function. By permitting the judge qua judge to develop the law in cases where other interpretations of the judicial function would not, common law review best justifies the judicial practice and process of adjudication. Consequently, according to Dworkin's theory, common law review incorporates the best interpretation of the common law judicial function. The belief that the judicial function is exhausted by enforcing existing law is then just one interpretation of the judicial function. Similarly, the belief that judges must adopt a posture of moral abstention is likewise an interpretation of the judicial function. Moreover, as I have explained, these are interpretations at odds with the traditional common law conception. Common law judges were never supposed to be the factotums of the legislature, and were never expected to disengage their moral faculties when they put on their robes. The common law always understood that inside those robes are human beings. Common law judges have always been expected to bring the full panoply of their moral sensibilities and life experiences with them to the bench, while exercising independent judgment about the laws they are asked to enforce. It is worth pausing here to make a clarification. In this discussion, one must distinguish among three factors. 1. The legal basis and authority for a judicial power recognized within a legal system. 2. The form of that power. And 3. Judicial attitudes toward the exercise of that power. Take constitutional review as an example. One must determine where that power comes from, what that power allows judges to do, and when judges may properly exercise that power. All of these are contingent facts about particular legal systems, and all are grist for debate and disagreement. People disagree about the legitimacy and foundation of constitutional review in America. People could also disagree about what constitutional review empowers judges to do. In America, when judges declare statutes unconstitutional, they are eliminated from the body of viable law. But this need not be the case. As in discussions of Bonham where people argue about what it means to adjudge a statute void, it is a potentially open question settled in the United States whether constitutional review automatically empowers judges to remove constitutionally offensive statutes from the law. I will discuss this issue relative to common law review later. Most important for my current discussion, the existence of constitutional review in a legal system does not necessarily dictate anything about the occasions when judges may appropriately exercise that power. Judges who agree that they possess the power of constitutional review may and do still disagree about whether they should exhibit restraint or activism in their exercise of that power. The same holds true for common law review. I am now arguing only for the existence of the power. Later, I will argue for the form I believe that power should take. I will also argue later that the proper judicial attitude toward the exercise of common law review is one of care and restraint. At the risk of belaboring the obvious, I should stress that one may accept the existence of common law review, but disagree with me about the proper form of that power, the appropriate judicial attitude toward it, or the correct instances of its application. Consequences of judicial failure to develop the law. To analyze the consequences of judicial failure to develop the law by refusing to enforce unjust laws, I place these consequences into three categories. 1. Legitimation, 2. Social and legal harm, and 3. Complicity and accountability. While there is some considerable overlap among these categories, they are distinct from one another and worth considering separately. 1. Legitimation. Writers sometimes refer to the legitimation of statutes enforced by the courts. The idea, usually associated with constitutional review, is that judges endorse, at least implicitly or indirectly, those statutes that they conclude do not violate a constitution. To be sure, the simple determination by a judge that a statute is not unconstitutional need not indicate any measure of judicial approbation. But as a practical matter, it frequently is taken to do so. Furthermore, even though the courts in these cases only permit actions taken by other governmental actors, the courts are often the chosen targets for public anger and outrage. Although one might assume that most hostility is directed at instances of judicial activism, in which the courts strike down legislation, it is usually the other way around. The harshest and most extreme reactions often come when judges fail to invalidate challenged legislative or executive action. I think, as I will explain presently, that people react so angrily to these incidents of judicial inertia because they expect more of judges and the judiciary in combating injustice than they expect of the more representative branches of government. At this point, though, I want to compare legitimation in constitutional review with legitimation in common law review. In much the same way, and with the same qualifiers that attach to legitimation as a corollary of constitutional review, judges who enforce unjust laws help to legitimate the iniquitous actions or relations permitted or encouraged by those laws. Despite whatever language the judge may use to distance himself from his decision, the result for the litigants and the public is that the judge has determined that their nation's law permits this atrocity. No language can place enough distance between the judge and this ruling. Judges do not write unjust statutes, but judges do decide whether to enforce them and are ultimately responsible for the laws they enforce. We can take Plessy as an example once again. Judges did not invent segregation, but as Herbert Hovenkamp argues, the judges who upheld statutes permitting segregation must share some of the responsibility for the racism that their rulings helped to legitimate and perpetuate. The courts must bear a heavy share of the burden of American racism. An outpouring of recent historical scholarship on racism and the American law reveals the outrageous and humiliating extent to which American lawyers, judges, and legislators created, perpetuated, and defended racist American institutions. Legal rules recognized and justified racism. More importantly, legal rules enforced racism by making segregation and the other degradations of racism a legal duty rather than an act of individual free will. In the process, they cleared the consciences of white Americans by relieving them of any sense of responsibility for racist practices. The perception of absolution is perhaps the most insidious element of the judicial legitimation of unjust laws. Notwithstanding any judicial protestations to the contrary, the stamp of legality and the air of credibility lent to unjust laws through judicial enforcement sends an unmistakable message to the law's proponents and to its victims. The courts cannot or will not prevent the practice the law permits. Moreover, those who favor an unjust law that is upheld are not responsible to the victims, because the courts will not hold them responsible for their actions. The courts have told them that, legally speaking, they have done nothing wrong. 2. Social and legal harm. Legitimation only opens the door. The further consequences of judicial enforcement of unjust legislation are often much more dire. Plessy and Brown serve as historical evidence of the damage done by judges who failed to develop the law where they should. The damage done is legal and social. Addressing the legal damage, Plessy planted the doctrine of separate but equal more firmly than before in American law and particularly in the Constitution. The case embedded a still more pernicious principle into constitutional law. That separation without reference to equality met the test of the Reconstruction Amendments. Plessy paved the way for the first wave of legislated transportation segregation, enacted between 1887 and 1892. This had two immediate results. Black travelers who sought accommodations in white railway cars were no longer just denied access, but were subject to criminal prosecution, and railway carriers could no longer choose not to provide segregated accommodations, but were forced to provide them. The social damage precipitated by Plessy was incalculable. Buoyed by Plessy, Jim Crow laws flourished in the American South. From hospitals before birth to cemeteries after death, separate but equal set the legal status of blacks. 54 years after Plessy, one commentator found laws and decisions extending the doctrine to every type of transportation, education, and amusement. To public housing, restaurants, hotels, libraries, public parks and recreational facilities, fraternal associations, marriage, employment, and public welfare institutions. It had pursued the Negro even into prisons, wash houses in coal mines, telephone booths, and the armed forces. The separation extended as well to inanimate objects. As in Florida, where school textbooks which had been used by one race were to be stored separately from those used by the other race. After 1896, Plessy provided judicial authority for this degradation. The human cost of a judge's decision to enforce an unjust law can never be calculated, but that does not mean it cannot be considered. America and Americans still suffer from the damage done by the court in Plessy. And Plessy is hardly the lone instance of judges enforcing unjust government action that legally authorized racial discrimination. Prigg v. Pennsylvania, Dred Scott, Hirabayashi, and Korematsu all represent sad chapters in the history of judicially enforced racism in America. All of these cases demonstrate the consequences of judicial inaction. These are the consequences that common law review seeks to avoid. When a judge fails to develop the law where she should, she does not only fail those who appear before her and the institution she helps to constitute. She fails the common law system itself. She retards the progress she is supposed to ensure, and she further embeds the injustice she has been asked to rectify, making the task even more daunting for her successors, to whom she has left it. 3. Complicity and accountability. For the two reasons I have just discussed, among others, we are often piercingly disappointed when judges enforce unjust laws and impede the law's development. While reactions to Brown were sharply divided when the decision was announced, most Americans now revere the decision as a very positive step for American law. Likewise, most Americans deride Plessy as a blight on American legal history. Two factors explain these reactions, and each of these factors reflects, in one form or another, one of the most fundamental aspects of the common law judicial function, expressed by Owen Fiss as follows. The function of the judge, which is both a statement of social purpose and a definition of role, is not just to resolve disputes, but to give the proper meaning to our public values. First, every judge is a constituent member of the judicial institution. As is true of any institution, the judiciary is understood by its participants as having a particular character or purpose. Officials of an institution have a duty to protect the character of the institution. One irreducible element of the common law judicial institution is its relationship with the effort to achieve justice. Many of the public values we associate with the law and the judiciary, equality, liberty, impartiality, and so on help to comprise the more expansive public value of justice. So when a judge preserves equality or liberty, we see this as promoting justice. We claim our more specific, derivative rights to equal protection, freedom of speech, due process, etc., through the common law judicial process. And judges recognize, promote, and defend these rights in their legal rulings. When a judge acquiesces in injustice for whatever reason, that judge fails in his duty to protect the character of the judicial institution. When a judge fails us, we believe that the courts, as an institution, have failed us. By failing to give the proper meaning to our public values, the judge has betrayed the character of the judicial institution. The disappointment we feel on these occasions is, at some level, personal. We live in this society. These are our courts. This is our law. We expect more of our institutions than this. We expect more of our judges expressly because of their role, its responsibilities, and its relationship to justice. Judges are, in this respect, accountable to all of the members of the nation whose law the judge interprets, enforces, and expounds. Second, and related to the first point, judges are accountable to every litigant who appears before them. In a passage that would have pleased his grandfather, especially because it was written in dissent, Justice John Marshall Harlan Roman II wrote, "If a new constitutional doctrine is truly right, we should not reverse lower courts which have accepted it. Anything else would belie the truism that it is the task of this court, like that of any other, to do justice to each litigant on the merits of his own case. It is only if each of our decisions can be justified in terms of this fundamental premise that they may properly be considered the legitimate products of a court of law, rather than commands of a super-legislature." Harlan's statement demonstrates the felt obligation, at least on the part of some judges, to gauge their results by the ultimate test of substantive justice. It may well be true, as Justice Brandeis said, that it is usually more important that a rule of law be settled than that it be settled right. But this is not so in cases involving unjust laws. These are occasions when nothing is more important than that the law be settled right. When judges are asked to enforce an unjust law, they have no greater obligation to the litigants and to the judicial institution than the concerted effort to develop the law and to realize the most just result. Only in this way can a judge look in the eyes of each litigant who appears before her and bear the conscientious assurance that she has done everything she can in her power and within her role to infuse our public values with their most noble content. As I explain in the discussion of the relationship between common law review and stare decisis in the next chapter, unjust laws present a situation where the concerns of formal justice, stability, predictability, continuity must yield to the demands of substantive justice, fairness, rightness, dignity. Judges are accountable to their institution, to the litigants who appear before them, and to the public that lives with and by their rulings. When judges enforce unjust laws, out of excessive deference to the legislature or a stunted view of their own function, they become complicit in the injustice that their office exists to prevent. Once again, Plessy serves as a historical reminder of this relationship between judicial duty and public values, and of judicial accountability and complicity. As Gerald Postma puts it, segregation, then, was not merely a matter of the private opinions or attitudes of whites in post-Reconstruction America. It was the public expression of a structure of domination, and part of a systematic denial of the standing of blacks as full and equal members of American society. It is not surprising, then, that Justice Brown, writing for the Plessy majority, and Justice Harlan paid scant attention to the question of whether the separate traveling accommodations were in fact equal in their separate quality, and why Brown sought to deny, and Harlan to assert, the law's complicity in the structure of social inequality. The most important lesson of Plessy, as I read it, lies in Justice Harlan's articulation of the fundamental evil of segregation. We cannot responsibly deny that racism still exists, but equally we cannot responsibly accept that it is just in the nature of things. We commit the morally unconscionable error of the Plessy majority yet again if we contend that law can and must do nothing to remove its sting. By claiming that judges must give the proper meaning to public values, I do not mean that judges must necessarily enforce and reinforce their society's prevailing social norms. On the contrary, when a judge refuses to enforce an unjust law, she will, almost by definition, frustrate the wishes of many people who support the law, not least those who have sought its enforcement in her court. The Louisiana statute at issue in Plessy was, after all, the product of a majoritarian legislature. Reprehensible though the statute was, we expect legislatures to act in the interests of the majority. And if it proves nothing else, history amply demonstrates that the majority will frequently want things detrimental to the minority. For this reason, among others, the common law has, at least since Coke's disputes with King James, placed the courts in a position independent and insulated from the political pressures and accountabilities endemic to the politically representative branches of government. Judges are accountable to something less tangible, but no less important. In response to Ronald Dworkin's claim that the United States is a more just society than it would have been had its constitutional rights been left to the conscience of majoritarian institutions, Jeremy Waldron questions whether judicial review is necessary as an institutional antidote against legislative injustice. Waldron even wonders whether Brown itself was necessary to discontinue segregation in America. Should we accept this as a starting point? I have my doubts. Like any claim involving a counterfactual, more just than it would have been if. It is an extraordinarily difficult proposition to assess. As we consider it, we think naturally of landmark decisions like Brown v. Board of Education, and the impact of such decisions on desegregation and the promotion of racial equality. But it is not enough to celebrate Brown. Verifying the counterfactual would involve not only an assessment of the impact of that and similar decisions, but also a consideration of the way in which the struggle against segregation and similar injustices might have proceeded in the United States, if there had been no Bill of Rights or no practice of judicial review. Waldron then goes on to mention 2 points that he sees as challenges to Dworkin's claim. 1. Some countries are as just as the United States, even though they lack an established practice of judicial review. And 2. Judicial review has sometimes damaged the cause of justice. To my mind, Waldron's argument misses the point and needlessly complicates a simple issue. Waldron may raise doubts about where Dworkin begins, but it is difficult to dispute where Dworkin finishes. Judicial review has eliminated from American law instances of unjust legislation. Plessy declared that segregation by statute was constitutionally permissible in the United States. As a result, segregation flourished in the American South. Waldron cannot seriously doubt that Brown improved the law that Plessy helped create. We can wonder whether segregation would, at some point, have grown so distasteful to those who lived in areas where it was practiced that it would have died a legislative death. But there is nothing in the almost 60 intervening years between Plessy and Brown to encourage us to think so. More to the point, the issue is not whether legislatures sometimes correct injustice or courts sometimes contribute to it. They do. The important point is that courts sometimes are the only governmental authority capable of resisting and correcting legislative injustices that reflect the prejudices of the majority. Majoritarian legislatures are decidedly unlikely to rescind legislation that continues to represent the interests of the majority, even where those interests are hateful, prejudiced, or ignorant. The common law recognized this long ago. For at least the last 300 years, the common law has recognized the court's unique, independent institutional position and capability to correct injustices committed through legislative or executive action. Even Waldron cannot deny that courts have, on some notable occasions of which Brown is an example, improved the law by excising unjust legislation.